Well, needless to say, Judge Martin wasn't very interested in looking at our evidence and stated that we had produced nothing new, and so we were consigned to an appeal to the United States Court of Appeals for the Second Circuit, the chief judge of which at the time was Earl Warren's former senior law clerk, who reserved this case to himself as head of the appellate panel. And his take on the case was that Mr. Groden had ample opportunity to present evidence outside the pleadings, but that we had failed to present facts supporting the claim of false advertising. And despite the fact that we had actually objected to expanding this lawsuit to include the assassination controversy, Newman also said that Groden's real interest in filing this suit was an attempt to use the courts as a forum for ascertaining the facts, as if, not that there's anything wrong with that, but as if it's some great abuse of the judicial process. I want to also mention something about Mark Lane, who also brought a suit because his photograph was used in the same advertising campaign. He brought suit down in the district court for the District of Columbia. I did not represent him. He was represented by a very fine attorney who had once served as a law clerk to Judge Henry Friendly of the late Henry Friendly of the Second Circuit. And here's what Lambert had to say about Mark. Random House, in publicizing its own book, has publicized Lane's as well, so they did him a favor by attacking him in this ad. And he called it a comparatively bland charge and a constrained chastisement. It's quite simply untenable that someone espousing Lane's views would take umbrage at the rather reserved assessment that he misled the American public. This is the federal courts. Under Lane's lopsided rules of engagement, he gets his choice of weaponry and tactics. Random House must do battle unarmed and march openly in a straight line. Well, I've never seen, I have seen judges attack litigants before, but considering Mr. Lane's longtime membership in the bar, his standing in the community, I have not seen a litigant attacked like this in a very long while. If Judge Lamberth's solution was if Lane is offended by this kind of advertisement, he may elect to minimize his exposure by opting for a lower public profile. This is a photograph of the attorney on your left who represented Random House and the New York Times and Mr. Posner in this litigation. The woman on the right is Judge Judith Kay, the Chief Judge of the State of New York and the Chief Judge, of course, of the New York Court of Appeals. Judge Kay is presenting my adversary with the John J. McCloy Memorial Award. So, look, after 40 years, what do you expect? I have to say, I have to tell you that as a result of my criticizing Judge Martin for his decision and trying to disqualify him, I was disbarred from the practice of law in New York. I state this not to appeal to your sympathy, but as a cautionary tale. This is what it means to stand toe-to-toe, even 40 years later, with people who regard criticism of the Warren Report and the continued investigation of this case as a threat to public tranquility, as a threat to respect for public officials and public institutions. It's dangerous work. And all I can say is mostly especially to the younger people in the audience, never give in. Dr. King taught us that the arc of the moral universe is long, but it bends towards justice. Never give in. Bobby Kennedy warned us. Justice delayed is democracy denied. Never give in. For it is written in the book of Job, there is no darkness nor shadow of death where the workers of iniquity can hide themselves. And the prophet Isaiah tells us, He giveth power to the faint, and to them that have no might, he increaseth strength. Never give in until the truth is known, until justice is done. God bless us all. Thank you very much.
Although I'm certain that it will do nothing to discourage the conspiracy peddlers, there is no evidence of a conspiracy in the assassination of George Hammond. Those are our findings. The evidence will be available to you as soon as possible. Thank you. This is an announcement, gentlemen. There will be no questions.